Hi everyone, welcome to the first workshop for JEAP 4. This is an introductory workshop just to give you a little bit of background about JENGBA. I'm going to introduce you in a moment to two very significant JENGBA members, and we're just going to give you a bit of an overview about what we would like you to do whilst working on JEAP 4. So I'd like to introduce Gloria Morrison and Charlotte Henry, who I'm going to pass over to in just a moment. They are both, as I've said, significant members of JENGBA, which is Joint Enterprise Not Guilty by Association, and I enjoy working with both of them a lot. Gloria, so you co-founded Joint Enterprise Not Guilty by Association. How did that come about?
Yeah, I did. I co-founded it with Janet Cunliffe when Panorama made a documentary called Lethal Enterprise about my son's best friend's case and Janet's case, her son Jordan Cunliffe's case. They were trying to focus on Jordan's case, but the judge had put a gagging order on his eyesight. Jordan's blind, and we couldn't actually say that on air that he was blind. Anyway, when I met Janet, we kind of were talking about it, and between us I said we need some kind of campaign, because my son's best friend was involved in a fight that he didn't start. He was being attacked. He was unconscious on the floor when unfortunately one of his friends came from a house, saw him being attacked and used a knife, and there was a fatality. He was a 19-year-old young black man, and he got a life sentence for murder, even though he didn't have a knife. He didn't know they were going to come out of the house with a knife in. He didn't intend or foresee that a fatality would happen. And I didn't understand how someone could go to prison for murder for a crime that they hadn't actually committed, in terms of, you know, the seriousness of what we think murder is. You need to have the mens rea, the actus rea, all that. Anyway, and I didn't have any legal background. I just was upset that, you know, a young man could go to prison for life for something he hadn't done. So on meeting Janet, who you'll meet in another webinar, we decided, just two women in the kitchens, to start a campaign which we called Joint Enterprise Not Guilty by Association, and that was in 2010. And yeah, that's we're supporting over about 1,150 prisoners now, mainly serving mandatory life sentences. We are predominantly mothers, predominantly women, but there are lots of dads and uncles and brothers involved as well. But it's mainly mums who just don't understand why our loved ones are in prison for life sentence. I met Sally and Charlotte Henry pre-trial, which is quite unusual. We don't often meet families before the trial, because they're going through something very, very traumatic, and they don't believe that their loved one is going to be convicted of something as serious as murder, because they don't understand what joint enterprise is. It's like, well, that, you know, when I first looked into joint enterprise, there was a joint specialist in Australia, and no one knew anything about joint enterprise. It was just something, you know, that people thought that if you're co-involved in a crime, you can go to prison for it. So yeah, met Sally and Charlotte when Alex was on trial, and it just so happened that another documentary filmmaker was trying to do a case, and they wanted to film a pre-trial case. And luckily, Sally and Charlotte and Alex agreed. So that documentary was called Not Guilty by Association. So I'll just hand over to Charlotte now to explain her involvement in the campaign.
Yes, I joined JENGBA in 2013. That was when my brother was charged with murder. I googled joint enterprise and JENGBA came up. So I think either me or my mum emailed Gloria, and we've campaigned with JENGBA ever since, obviously starting with the documentary. My brother's been in prison now for 7 years, and he failed his appeal, and we're waiting on the CCDRC. Yeah. I don't know what else I was meant to say.
But you've had quite an interesting journey, haven't you, in terms of where you work now, and kind of what has driven you into where you work now. Do you want to just talk a little bit about that?
So at the time of my brother was charged and convicted, I had a law degree from Brunel University, but I only got a 2-2, and law was very competitive. So I kind of gave up on pursuing a career in law and was working at probation at the time. But then when my brother was convicted, I kind of realised, the potential for really, really expensive legal bills in the future. And it could also come to a point where no lawyers want to continue and take his case. So I thought that I should become a lawyer. It's very expensive to do an LPC or a BPTC. I think it's 15 to 20 grand.
It's a lot of money.
Yeah, so I didn't do that route. I did the Silex, which was about £3,000, and you don't have to get a training contract. So you pay £3,000, you study 2 subjects, the same as what you would do if you were doing an LPC, except that they do 7 subjects and we do 2. And instead of doing a 2-year training contract, we do 3 years qualifying employment as a paralegal. So anything wholly legal employment, so a paralegal. So you don't have to go out and compete for these training contracts. You just get a paralegal position and work for 3 years. And I think 2 of those years can be done before you've even done the Silex course. So that's the route I took, a lot more affordable, and especially for working class people to be able to get into the legal field. And I'm now a lawyer with Tucker Solicitors, and I do criminal defence. So I take on cases and appeal work.
Wow, that's quite a story. That's really good. And there'll be people listening to this that will be really interested in that Silex route, actually. So you may have made a bit of a rod for your own back there, with people kind of wanting to get in contact and trying to kind of figure out whether that's for them. So a bit more then, just about JEAP. What has it achieved so far? So you say kind of it was born, as it were, in 2010. Where are we now?
Well, I actually think that's quite interesting, everything Charlotte was saying about sort of the legal route she took, because most of the families that I know come to JEAP without any legal background at all. And a lot of them have never had any involvement with the criminal justice system at all. A lot of our prisoners have got no prior convictions. So the idea that you can go to prison for murder, but you've actually never committed any acts of violence or anything before, is actually I find that actually quite interesting, because it's partly my journey, that I think that I was sleepwalking back in 2010 when Ken was convicted. I believe we have a really robust criminal justice system. I believe that that we have one of the best in the world, and that that the idea that a jury will really look at evidence and to find, especially someone guilty of murder, to now, where I believe that we've probably got one of the worst justice systems in the world, because we use joint enterprise. It is such a stain on the British justice system that joint enterprise is allowed and continually allowed to be used. So back in 2010, this was, I believe, kind of brought in by, at the time, the Blair government, because joint enterprise goes back, Charlotte can do this, you've got case law which goes back to 1837, and they cite that often in the Court of Appeal, case law that goes really far back, that has no relevance to today, where you can get convicted of murder because you've received a phone call, or that you've got cell site that links you to someone who carries out a murder. If there's a way that you can be brought in by association, that doesn't really have any relevance to previous case law. So we started just as we're still a very grassroots campaign, but we got an inquiry at the Justice Select Committee in 2012, and then 2013 they revisited it. We had meetings with the then DPP Keir Starmer. We've had meetings with MPs. We've lobbied up and down the country. We've had various bits of media, until we got to 2016, where, well, it was 2015 where they decided to look into joint enterprise at the Supreme Court. So Felicity Jerry, who's the QC, got a question certified by the Supreme Court judges, which was, does joint enterprise overcriminalise secondary parties. That was the second part of the question. The first part of the question was whether Jogi, R versus Jogi, may or might have realised that a murder was going on in that house. He was outside the house. So it was those two words, which Charlotte will go into a bit more, I'm sure, may or might. And so we intervened, Jenga intervened in the Supreme Court judgment, and that was a pinnacle of the campaign so far, in that the judges accepted that joint enterprise had taken a wrong turn in 1984 with Chang Min Soo, which is a case in Hong Kong, and that it was relying on foresight, and that no longer should the courts rely on foresight to convict someone. They had to rely on intention. So that was in 2016 when that judgment was handed down. But they put in a clause, paragraph 100, which is, even though the law was been wrongfully interpreted for over 3 decades, only cases that could prove substantial injustice can go back to the Court of Appeal. So we had a stack of cases waiting to go back to the Court of Appeal. They're known as R versus Johnson, and every single one of them was refused by Lord Thomas. They said that none of them were substantially unjust. Then we took cases, the next batch of cases we took forward were children with learning difficulties, a case in Liverpool, R versus McGill, and R versus Henry, which is Charlotte's brother's case, which she can discuss. They were all refused. Then we went forward with another case, which was a girl called R versus Mitchell. Now, Laura Mitchell was in a car park. She'd come out of a pub with a boyfriend. They'd had a lock-in. They were drunk. They got into a taxi. There was a fight about the taxi by the people who had booked the taxi. Anyway, a fracas about a taxi. Unbeknownst to Laura and Michael, because she's looking for her shoes, one of their party runs to the other side of the car park 6 minutes later and kicks a man twice. Second blow is fatal. Laura and Michael find out about that incident the next morning, take themselves to the police station to say that they were involved in an earlier incident in the car park. They both get charged with murder of that individual, and they get convicted. Both of them are in prison serving life sentences. So we took Laura's forward because the idea that how could she have had possible foresight of what somebody else was going to do 6 minutes after the initial argument, and Lady Haylett dismissed it because she said that Laura had displayed conditional intent, which meant that she was responsible for the murder because of the fight at the beginning. Now, when that judgment was handed down, we realised that we were not going to get anybody through the Court of Appeal as it currently stands, because the judges are just refusing to accept that the law was wrongfully interpreted. We didn't interpret the law wrong. The courts have. Juries have been misdirected. But if you're not going to let a girl looking for her shoes in a car park, and you're not going to let Alex Henry through either, and Charlotte Henry can explain why Alex's case is so compelling, but also Jordan Cunliffe's appeal failed, and that's a 15-year-old blind boy who didn't touch the victim or see the victim. We know that the courts are completely biased to any joint enterprise cases because they do not want to set precedent. Because once precedent is set, that means, I was told by Lord Torson this, he was one of the Supreme Court judges. I asked him why they put in a substantial injustice clause, and he said, oh, because the commentators would be saying killers are being let loose. Now, the commentators of the Daily Mail and the Sun, they're not the general public, because the general public do not know about joint enterprise. So where we've got to is we've done everything we possibly could do in terms of the legal route, and we've done it calmly. We've marched, we have campaign, we do those kind of things, but we're being denied justice by the Court of Appeals. So that leads us on to one of the reasons why we set up the Joint Enterprise Appeals Project, which is what we're talking about today. So I'll just hand over to Charlotte just to discuss Alex's appeal.
So my brother was convicted in August 2013, and the law that was applied in his case was pre-Jogi law. So that was where you could be convicted of murder if you participate in crime A, and during the course of crime A, one person goes on to commit a further crime, crime B. If crime B is murder, and all the participants to crime A foresee that that crime B is a possibility, those who participated in crime A are also liable for crime B. So he was convicted under that interpretation of law, and therefore when Jengba successfully campaigned to reform the law, and the law was reformed by the Supreme Court, we applied for permission to appeal out of time on the basis of that the law was misapplied in his case. The test on appeal, when you're out of time and you're appealing on a change to the law, the test to be even given an appeal is very, very high. So instead of having to satisfy the court that the conviction is unsafe, that you might not have been convicted had the jury been directed in accordance with the correct law, the test is that you would not have been convicted. So in effect, having to prove that you are innocent. It's a very high legal bar, and it's one that my brother's case didn't satisfy. So that's something actually that Jengba are now campaigning to change. We've drafted a private members bill, and we're campaigning to try to get that through Parliament, a substantial injustice test, that high bar, and allow us to have an appeal out of time where the error now corrected might reasonably have made a difference to the jury's verdict, which is the standard safety test applied to every other case.
I'm just going to jump in there as well, because Charlotte hasn't mentioned this very important point. One of the reasons why Alex's appeal was taken forward is because Alex has since he's gone to prison, has been diagnosed with autism. So the lead expert on autism in this country, and probably in the world, is Professor Baron Cohen. He went in to examine Alex in prison and came away with the conclusion in his expertise that, yes, Alex is autistic. So kind of took that as a point of appeal, that how could someone with autism foresee in a 47-second incident where someone has used a knife which is concealed. Alex didn't know there was a knife present with his friend was carrying in a bag, but the friend, I went to Alex's appeal, the QC talked about Cameron in a way that was really compelling, that he'd been sofa surfing for years. He was he didn't have any strong roots. He was homeless a lot of the time, so he carried a knife probably for protection. But we can't go into the reasons why someone carried a knife. But Alex didn't know that, and he was autistic, so we took that forward on appeal. In the Court of Appeal, the Lord Chief Justice Thomas said that because Charlotte's mum is a psychologist, she had taught her son how to pretend to be autistic. And what would you do? You two brought the lead expert on autism. Oh, I can't do it. I get too angry. So that was that was the Lord Chief Justice opinion, that Sally had taught her son how to pretend to be autistic.
Honestly.
Yeah, and so if we're up against that kind of attitude in the Court of Appeal, we know they're not going to let anybody through, because that's just ridiculous that a boy with autism could have foreseen what someone else was going to do when it's a fight that all he does is throw his phone on the floor. That's all Alex does. So that was denied, along with other children with learning difficulties, the youngest being 13, who had a learning age of 8, I think, and Lord Chief Justice said no, they had a fair trial, even though they're not the principal. So I think that's what we're up against, and that's what young aspiring lawyers should know.
Yes, most definitely. It is a difficult area, and I know from students on the Innocence Project London that when they get a case that concerns joint enterprise, it blows their minds. When they then delve into the backgrounds, they hear you guys speaking, it just blows their minds that this is allowed to happen in modern society, in a modern criminal justice system. So Joint Enterprise Appeals Project, then, as you just touched on, Glo, was set up. So this is JEAP 4, it's in its 4th year, and it was set up to do just that, wasn't it? It was to create awareness and to get students involved in knowing about joint enterprise, knowing about the law, knowing about how the law has evolved, the reforms, and also trying to get a little bit of activism behind them in terms of taking it forward and coming forward with us in how we remedy it and improve it. Is that about right?
Absolutely. Yeah, that's absolutely really well put, Louise. Thank you. It's not an innocent project. We have to stress this because we don't have the capacity for students to look into, like what you see in the movies, especially in America with their innocence projects and with Louise's innocent project. You really need a lot of work and a lot of effort and a lot of the case papers. One of the things we've got is that people lose their case papers once you get into the criminals, once you're in prison. It's very, very hard even to just get your summings up. But luckily, I mean, this is our 4th year. The first year was the year after Jogi. So the students were looking for Jogi points, a point that maybe the judge had erred in directing the jury in terms of foresight instead of intention. And that was pretty depressing that first year, because even though students felt quite uncomfortable about certain cases, well, lots of our cases, they still couldn't find the Jogi points. So it's like the golden nugget and it wasn't there. So the second year we asked students to maybe just look at cases a bit more holistically. Don't just try and find a point of law, because you're probably not going to find them. If we can't find them, and we've got brilliant lawyers that have been trying to overturn this hideous law for some time. So we asked them to look at the cases more holistically, and then they came back with their reports, and their reports kind of had a bit more information about the prisoners, what was going on, how they were convicted. So it's actually looking to see what evidence was actually used to convict this person. So that try and look at the evidence rather than just what the judge says in their summing up. Now the summing ups are supposed to be unbiased, and they're not. They're absolutely not. The judge can direct a jury. I mean, we saw the case the other day of the police officer who strangled his girlfriend or his lover, and that's, and he got manslaughter. Whereas, our family's been jumping up and down saying, well, how did someone get manslaughter when they've actually strangled someone? And if you probably all know who the secret barrister, he did a thread on it, or she did a thread on it, and it was breaking it down that it was actually probably the judge's direction that this was manslaughter rather than murder. So that's what we will be sending out, mainly summings up, but students must feel like they can come back to us if they, you're not going to not do it because it's what people will do. But most murder trials are in the press.
Yeah. So
most students will probably go to see what was reported in the press. In fact, that's quite important because a lot of our cases, including Laura Mitchell, the girl in the car park, how the press report these cases is absolutely shocking. It's like she was a flailing they used a word for her, but it's, so they build it up that these are violent and dangerous people rather than actually what their involvement was. So we have to marry that up. We can't say you don't look at the press, but actually, we'll try and give you what the prisoner themselves say is, because we send out a questionnaire. So we'll give you the questionnaires as well. And so you can see what the prisoner says they're involved, what wasn't. And it's just getting a report on that. And actually, most of the universities are taking 2 cases. So I suggest most students look at both cases because you have to inform your opinion based on quite limited information, which is a judge's summing up, because we can't send you masses of case papers. We do have quite a lot of other people's case papers, but what we're asking you to do is just get an awareness of how joint enterprises was used and is still being used. I mean, there's an argument going on at the moment that it's not used, it's gone away. Well, it hasn't gone away because since Jogi, since 2016, we've had probably over 100 cases come to us since then. So it's still being used. And what we want you to do is, just examine how it's being used.
We are seeing, though, excuse me, and I know, Glo, we've had this chat, we are seeing a change in language a little bit, aren't we, in terms of joint participation and joint principles, very much that kind of description rather than parasitic accessorial liability. And I think, so just to give you some context in this workshop, your next workshop is going to be all around joint enterprise and Jogi, by Felicity Jerry QC, who's going to talk to you from personal first-hand experience about that case and just give you a little bit of an idea of where the law sits at the moment in slightly more depth. But certainly, Glo, we've seen the language changing a little bit in terms of judges describing more and more individuals that are brought into court under joint enterprise as joint participants or joint principals in an offence.
Yeah, yeah. I mean, in the Supreme Court, when they started talking about accessorial liability, which is known as POW, Charlotte can explain a bit more if you need to, but I believe it was Lady Hales did say, oh, this is a fairly new term. Now, as campaigners, we would say, well, it's because we've made joint enterprise something that people are aware of. But whereas before that, when my son's best friend went to prison, nobody knew anything about joint enterprise. It was just like, well, what's that? And when we, started doing before JEAP, Jan and I would go to universities and talk about cases, and most students would say, well, we've got a joint enterprise module on our course, but that's not what you're telling me is in practice is happening. And that's the thing, I think, especially with law students, it's that you've got to divorce the idea of what you're reading in law books and the reality of what happens in the courts, because the language, as Louise is saying, the language in a courtroom is so complex and so archaic, I would say, that it hasn't evolved in terms of the 18th century law. I mean, you have judges that use expressions like feckless. I mean, when you're talking about a woman, a feckless woman, what does that mean? Does it because she's got maybe a bit of a chaotic lifestyle or she uses drugs, she's feckless? And I would argue that, a lot of our defendants are not understanding their own case. They're not understanding the language their own lawyers are using, and especially children with learning difficulties are just not going to be understanding parasitic accessorial liability. What does that mean? What does it actually mean? Does it mean that I'm guilty because I parasitically knew what someone else was going to do? Anyway, so the language is very, very important, and I think it changes as to when people wake up to it. It's understanding. It's a lack of ignorance, and they think we just don't, us working class people, because joint enterprise predominantly has convicted working class, black and ethnic minority groups. So or individuals. I'm not going to call them groups because they try to use the gang narrative.
Yeah.
Often with young black men, they're all in a gang, and that's an easy way to convict because gangs all know what they're going to do. But you might have a 15-year-old that's maybe on the periphery, maybe selling weed, maybe doing something, but is not guilty of murder, but they will go to prison for murder. And I know that sounds shocking. It sounds like it's out of a science fiction movie, but it's not.
No, unfortunately it isn't. Charlotte, with your defence lawyer hat on, which I'm so pleased I get to say that to you now, do you want to just add a little bit there in terms of maybe just giving the students a little bit, some hints and tips for them in terms of what they need to look for, but also just say to them kind of about how much benefit they're going to derive from kind of doing this kind of thing? Because, if you're thinking back to when you were a student, and certainly when I was a student, this kind of thing would have been so useful and would have inspired me in terms of, where I might want to put some pro bono activity, where I might want to kind of, place my activism in the future. And I'm fairly sure, had you not already been involved with JEAP and were going down the law route anyway, from a law student perspective, that might have been something that you would have shared as well.
Yeah, definitely. I find it really interesting day to day when I get a new case. I guess I'd probably do it in this order. So I'd be past the summing up, and I would flick to the route to verdict.
Right.
So the route to verdict will be inside the summing up, and it's a list of questions that the jury has to answer yes to end up convicting the person of the offence. So the law as it stands, joint enterprise, that's where someone else commits the actus reus of the offence, and the participant, the accessory, intentionally assists or encourages the principal offender while not having the knowledge of the principal offender's mens rea and predicting what they would then go on to do, or knowing that they would act on that intention. So firstly, route to verdict. Does the formulation of the route to verdict, does that satisfy the law as it currently stands? If the case that you have is before February 2016, it might have actually been the application of PAL, which is the crime A, crime B scenario, in which case you would be looking at an appeal point immediately there, although having to satisfy the substantial injustice test. If it's a newer case, you just look to see whether it satisfies the current law. Once you've done that, okay, tick, tick, satisfies the current law on that, then the interesting part starts. You actually get to read the summary of evidence. So you read all the evidence, all the witnesses, what the defendant himself says. You might be given other documents like defense statements or witness statements before they gave evidence in court. Sometimes people have that material, most of the time they don't. So it will just be how the judge summed up the evidence at trial. So you look at that, and then you look at the evidence to see whether there was evidence to satisfy the points that were in the route to verdict. So, I mean, there must have been, because the jury was sure that they were convicted. But a lot of the time, so the jury could believe someone intentionally encouraged or assisted the crime. But actually, when you review the evidence, the encouragement or assistance is in presence alone. So like they could be just present, but the jury believed that they were deliberately present, intending to encourage with their presence, and did in fact encourage with their presence, being like the backup. So then basically get a feel of all the evidence and work out how the jury came to be sure and passed it through the route to verdict. Then you can look to see whether anything unfair has happened at trial. So was there any bad character? Did the prosecution allege that they were in a gang? What was the evidence to support that? Was there any hearsay evidence unfairly admitted? Also, trying to think what other things could come up.
Right to silence, potentially.
Yeah, right to silence. Whether the police didn't ID them. So if there's a known and available witness, PACE Code D says they must be identified. We'll go through an ID parade. If they fail to do so, and my guy's saying, I absolutely wasn't me, I wasn't present, and they failed to do an ID parade when the witness has said, I would 100% recognise this person again, then that could be, you could be looking at an abuse of process argument. Yeah. You could have potentially had any of the description kicked out under Section 78 of PACE. There are lots of things you could be looking at. And then I think last of all, because most of these cases, well, all of these cases would have had advice on appeal from very senior counsel saying that there are no grounds for appeal. So it's unlikely that you'll actually find anything. So at the end of it, put your jury cap on and ask yourself, would you have been sure? If you were the jury member, would you have been sure that this person was guilty? And see what you come up with.
That's a really good way of looking at it. And that will be really helpful. And for students listening that don't know what PACE stands for, it's the Police and Criminal Evidence Act 1984. And you have supporting academics. We've asked for academics in your institutions to support you this year. So with the likes of hearsay, right to silence, and any other terminology that Charlotte's gone over that you don't understand, do make a point of asking the supporting academic in your institution about those, because I'm very sure that they'll be able to give you a brief overview of those points if you do want them. So what are students going to get them from benefiting, or how are they going to benefit, from taking part in JEAP? We've touched on it, but Charlotte, what, drawing from your experience, what would you have benefited from taking part in this?
One experience of seeing a real life case. So you actually are presented with all the evidence of a case. It's not in a law book, a very small summary or explanation of what happened at trial. This is exactly what happened at trial. So that in itself, I think, is very useful. Sometimes, I mean, I don't know how jaded the students are. I was quite like the justice system, rose-coloured spectacles. And perhaps this could help them see that actually our justice system is incredibly flawed.
Provide a critical perspective, I think, is the polite way of putting it.
Yes, develop a critical perspective, especially when you look at cases that have come from St Albans Crown Court.
Excellent. A critical perspective from that court.
So I think that's very useful. I also think just understanding what the documents are, and then like Louisa said, approaching the faculty of your universities for information on bad character, hearsay. A quick Google search will explain those terms as well. Things are readily available on the internet, and obviously Westlaw is the best place to find that. And I think that will just give you a cut above it, because you don't tend to really look into bad character and hearsay and stuff like that so much until you're doing your postgrad diploma in legal practice. A lot of people might be doing sandwich courses and might want to put some of this information into their current internship. A lot of people don't know what a summing up is. A lot of people don't know the correct direction to give when someone's been ID'd, the Turnbull direction, and then you actually get to see what one is during the directions in law. So yeah, just seeing like practically when people talk about these kind of phrases, what they are and how they are applied in the actual courtroom itself.
Excellent. And so I think the last thing to touch on then is, so JEAP 4 is going to provide a very unique experience for students, for you guys listening to this. But as well as taking part in JEAP in that way, we quite like students to harness a little bit of their activism towards joint enterprise, and certainly to support JENGBA. So I know JENGBA is on Twitter, it's on Instagram, it's on Facebook, which I'm sure as students you are all over. Instagram still confuses me, but I'm getting there slowly but surely. I sound like a complete technophobe. What do we, I mean, the hashtag is hashtag JEAP4, which I will put in the email to you, and that can be used across all the socials. But Glo, how else do we want students to get involved?
Well, you know, because we're in these times of COVID, what I would say, I used to go around and did lectures, would say, just go and talk about it. Go and tell. Did you know, when you next time you're in the pub, talk to people. So have you heard about this thing called joint enterprise? Because it is such a dangerous doctrine. There's an argument about whether it's a doctrine or not, but it is very, very dangerous. And, you know, like I said, 2010, there was nothing out there. And you go on our website now, we've had lots of academic reports. We're going to have another academic report come out very, very soon. And that academic will come and talk about her report, because it's about joint enterprise and women. And the reason I used the word feckless earlier was because a lot of these women are, that in the report, none of them are guilty of actual violence. And it is much more about their right to be women, or and anyway, that's another very important report. But just support the campaign. Well, you know, I'd like you to have your rose-colored glasses on and law glasses, and then, you know, be informed and be critical. But you know, campaigns like JENGBA don't come from nowhere. They come from a very deep-seated sense of injustice, and when you get that under your skin, I don't believe it ever leaves you. My boy's near the end of his sentence, and but I won't stop. So you know, but I'm going to have to stop soon because I'm getting old, and you know, we need to hand the mantle over to people like Charlotte and Louise and yourselves. So that's what I want. I want you to kind of give it a verb. You get JENGBA'd. You will get, yes. Most people do, and you know, and if you want to be going into a practicing world of a good criminal justice system, then this needs to be addressed as an urgency, matter of real urgency. We've tried everything. We need students to get behind us and support us, and actually sign our petition, go out and start up your own anti-joint enterprise groups. So yeah, just that the activism side of it is as important as your critical learning side of it.
Definitely. There is a lot already. If you're not already on Twitter, get on Twitter. If you are, look for JENGBA, give them a follow. They're on Instagram and Facebook as well. So do look for them. Do follow their pages. Do get an idea about what they start tweeting about, what they're talking about on social media, because there's a lot out there, and nearly every single day, especially on Twitter, there is a tweet from a member of JENGBA about something and about one of the cases they're supporting. So it is really important. And do tweet and say that you are taking part in JEAP 4, hashtag JEAP4, because we want you to be proud about it and we want you to be involved. So I think that's us. I think we're done with this, with the first workshop drawn to a close now. So thank you ever so much for listening. As I said, the next workshop is going to be delivered by Felicity Jerry QC, and it's going to be about the Crown and Gates Jogi. So more on the law side, and that will certainly give you an idea in terms of when you're looking, as Charlotte has said, when you're looking at the summing up and you're looking at the route to verdict, and you're considering kind of the current law or whether it was pre-2016, in which case you're looking at the previous law there. So thank you very much to listening to us. We hope you've enjoyed it, and on behalf of Charlotte, Gloria and myself, thank you ever so much.